Hi everybody, my name is David Myrland. This is the first video presentation that will be placed on the web to introduce folks to WEvGOV.com. We versus government. When government is bad, when government is good, I don't have an issue. I need good government. When government is good, I don't have to worry about the guy out there that's bigger than me who wants my wallet, because I know I can get on the phone, call 911, and have assistance, knock on wood, within hopefully a reasonable amount of time, and have assistance with things that are beyond my control. Those in society who can't protect themselves against everybody, they need, they deserve, and they have paid for that assistance from government, that protection when the roads are full of potholes. Well, they should never get to the point where they're full of potholes, but when the roads need repaired, when the lines are down, whatever, we need government. And we paid a lot of money to make sure government is there for us. Government has gone astray in far too many areas for me to accept, and a lot of people view government as totally overboard. So WEvGOV was established. It's just a website right now, but we're going to operate as a panel to whom people can bring their complaints of misconduct on the part of public servants, and the panel will evaluate the evidence, compare it to criminal statutes, and if the panel believes that a crime has been committed, issue a statement, sworn statement, penalties of perjury. We, the panel, we believe under penalties of perjury this crime has been committed. Issue a statement in triplicate. One will go on the website on the docket. One will go to the perpetrator, the accused, and another one for the records of the accuser, so that the accuser can now go with this copy of theirs to the superiors of this public servant and work on getting them fired. Hopefully the violation about which they're complaining is a felony, because if nothing happens to that person as a ramification of having breached their contract with their employer, it doesn't matter whether it's the cop, the mayor, it doesn't matter. If they have violated the law, they're outside their office. And if they're outside their office, they're not getting paid to do that. And their boss should fire them, discipline them, and if it's not satisfactory, especially if it's a felony. Do you know what I can do to a felon? I have the common law right, and it is codified in Washington state law. I have the right to arrest a felon with any necessary force and take them to authorities competent to receive them into custody. Nothing you'll hear me say, ever, is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. That's been my disclaimer for years. And so I don't give legal advice. I'll show you what the courts say. I'll show you what statute says. What you do is your responsibility, your prerogative, and your problem if you handle yourself incorrectly. We have public servants that think what they do is appropriate, when what they do is abhorrent to normal people. The instance of Michael Idland, Washington State Patrolman, pulling over women that he saw leave cocktail lounges in contrived drunk driving stops. He pulled them over, sexually assault them, arrested some of them so he could assault them again at the precinct. And the FBI did an investigation, and 7 women provided affidavits, which I've read, that outlined the conduct of the officer while on the job. He was in King County Jail for 16 months pending trial, receiving administrative monthly pay, and was allowed by Judge Palmer Robinson in King County Superior Court here in Seattle to plead out to gross misdemeanor, custodial interference, so that he didn't have to register later as a sex offender. It's an atrocity. But what is it? Because I have to ask. I can't answer the question. What is it to a woman that happens to observe that? That basically that red carpet rolled out for this molester, to the detriment of every woman in the future who has a similar episode to report. They now know the judges stand to protect the police, even if the police are doing that. That's only one instance. So, but it's a great example. I've been on the phone, conference calls, radio shows, and one-on-ones with victims for over 20 years. I've been a legal advocate for 22 years. And I don't have confidence that there are good cops. It's all been wiped out. I say the benefit of the doubt disappears when all there is doubt. There's no benefit when all there is doubt. All I have are doubts. And locally, in one evening, one instance, a whole police precinct department and a whole county sheriff's department on scene, beating and torturing a crippled medical marijuana patient. They cut all the cords off of his appliances. They ruined an $800 silk Taiwanese tuxedo, took a car key to each of his guns and scratched her from the tip of the barrel through the stock, broke into his safe and stole $20,000 to $30,000 dollars worth of gems and precious metals. He used to be a jeweler. Knocked him to the floor and dragged him around his apartment by his long hair. Kicked him in the stomach so hard he got a fractured liver. The doctors, for the life of them, can't figure out why he's still breathing. The only one out of 1,800 lacerated livers that they've seen survive. And not one reprimand to any degree was given to any of those officers over what happened that night. And everybody knows. Rick Bart was the sheriff in Snohomish County. Knew all about it. Well, before he was sheriff, I think he was 15 years in the DEA. So he's got the federal mental retardation that says we should spray Iraq with depleted uranium ammunition so that for generations children die in the womb. That's who we're up against. I specialize, and I played it straight for several years. I was nice in my pleadings. When I would write for somebody, I was practicing law without a license for poor people that couldn't afford attorneys. And I never worked for guilty people. And I played it straight in my pleadings. And I'd write a 15-page memorandum for somebody trying to get their case dismissed. And I'd watch in court while the prosecutor over here on this side, with 1 page of paper, could put somebody in jail. I'm just going, I'm cranking out the memorandums and briefs, and I'm reading case law like it's going out of style here just to manage. And this prosecutor's over there with 1 paragraph and people are going to jail. How do they do that? And so I started studying the prosecutor's job. And I made it a point to read cases, decisions, where cases got dismissed. Charges dismissed. I studied why charges get dismissed. Some are dismissed because of procedure. Some are dismissed because of misenforcement. Some are dismissed because the statute's unconstitutional or the conduct's unconstitutional against them. So there's a bunch of categories I have in my head of why cases get dismissed for different reasons. And so when somebody gives me all their facts and I learn to a certain point that their case should be dismissed, I have enough to write the brief. But back to this point where the prosecutor can put somebody in jail with 1 paragraph, what are they doing over there? That's power. They're enforcing the criminal code. And so I started reading the criminal code. And it answered all my questions. How could they do this to me? Look at them. What? I read the criminal code. I go, they're committing crime. Here's the crime. Here's the crime. Here's another one. Here's another one. They live in the criminal code. And when you pair that fact, when it becomes a fact to you, I'm speaking on my own behalf, what you decide is your business, but I'll show you why I believe what I believe. I call it a fact, I can prove it, nobody can deny it, and so I'll gladly offer you what I have. When you take that fact and put it beside the fact that all the courts say when a felony's been committed, you have the common law right to arrest the felon and take him to the authorities. Suddenly, you put pieces of this puzzle. It's not a puzzle. You just take all the tools in the shop and you put them all in front of you, and then you take, I don't need the table lathe for this one, I don't need the screwdriver, I don't need the pliers, I just need these several tools, and I can form my own power. To where the prosecutor, one page of paper, well, Dave and the panel members and the accuser, the victim of the crime, can come to the panel and say, look, I have this instance of abuse here, and with this presentation, let's look at all the facts. And let's decide, has a crime been committed? And if so, is it a felony? And then write a statement for the accuser that says, a felony's been committed. We are not the emotional victim of the crime. We are disinterested persons, and we've been studying. We're not just the electrician or the plumber or the cashier at 7-Eleven. We've been studying. And we sit on this panel to hear accusations of crime from victims because government is out of control. And in this instance, the officer knew, because this person had already served the city with notice. Hey, I didn't get a notice of hearing on that traffic infraction. You sent my notice of contested hearing to the wrong address, and so I want you to quash the warrant. Because I would have appeared at the hearing if you told me that it was going to take place. But you sent the notice to the wrong address. And I sent this to the city 30 days ago. And you arrest me today? The panel's presumption is that the officer knew they didn't get a hearing on their ticket and that the warrant was false, and he arrested him anyway. I call that unlawful imprisonment. That's a Class C felony under Washington state law. 9A.40.040 is the statute for unlawful imprisonment. Ding! I just rang the felony bell on that cop. When the felony bell sounds, tell me if this isn't hell breaking loose. Anyone with knowledge of felonies being committed, whether in their presence or otherwise, if you have a reasonable suspicion that a felony's been committed, you've acquired the dominion over the felon to arrest their person and take them to the authorities with any necessary force. State law says so. This is where I'm going with WEvGOV. Accountability. That's what this is about. It's not about all government, it's about bad government. That's all. That's all it is. But we know there's plenty out there. So it's a target-rich environment for somebody that's studied the law. I am not part of the anti-tax movement, the patriot movement. I have nothing to do with them other than to review cases of people in trouble because they did what the movement says to do. The movement hasn't moved since I became aware of it in 1990. They're still arguing Uniform Commercial Code, non-resident alien. I've got a 1992 memorandum from a U.S. District Court Chief Judge that kills that argument. 1992. It's 23 years later, and people are still arguing it. Plenty of other, I could go through a litany of arguments. It is November 19th? November 19th today. December 9th, about 3 weeks away, a little more, in Anchorage, Alaska, James R. Back will be sentenced in U.S. District Court for, I think it was 6 counts of tax evasion and 5 counts of failure to file, something like that. Because here's a man, I think he's 61 now, an Alyeska pipeline technician making over $125,000 a year for many years in a row, according to the indictment. And in 2000, for the year 2006 through 2012, he filed Pete Hendrickson tax returns, cracking the code. And he's about to be sentenced to between 5 and 13 years in prison. What does he lose with that? His reputation. His job, 125 grand a year. The 5 years he would have otherwise worked on the pipeline, so that's over nearly $1 million he's going to lose. And you'll have a felony record when in fact Pete Hendrickson has already been to prison and been released and is out pushing his book again. Add to that, now, take from Caesar.us. On the left-hand side, you'll see Cracking the Code by Pete Hendrickson, a review. There's my review of his book. There's several links with that. It says more. Each one of those is a link to a blog with people describing the trouble they got in for doing what Pete Hendrickson prescribed. He caused tens of thousands, it's easy for me to say that, tens of thousands of levies on bank accounts and paychecks. And he's out pushing his book again. So I'm not part of the movement. I have nothing to do with them. I have nothing good to say about them. And through this process at WEvGOV.com, anybody that cares to make any arguments that the movement makes, I have nothing to do with you. You no longer have the right to use WEvGOV. I'm copyrighted. And all the derivatives thereof. They're copyrighted. I've got an ISBN number on it. And so you won't associate with us if you use any of the Patriot Movement's arguments. For starters, we are keying upon 3 arguments. But when you see the 3 arguments, and all that you need to understand the arguments is already on WEvGOV.com. All of it is already there. When you see the 3 arguments, I feel, you'll be hard-pressed to identify a public servant who is not proven to be a felon. Okay. So why wage those other arguments when you have the authority to arrest everybody but the dog catcher? Why would you go with another argument? This is called a step forward. That's a movement. I've been accused, boy, Dave sure toots his own horn. Excuse me, I'm the only one with a horn. Hello? Show me anybody else that even has a horn to toot. So, I don't care if somebody calls this arrogance, definition of arrogance, unfounded confidence. I can prove everything I say. So it's not unfounded. I'm simply angry and I'm accurate, which makes me unique. Kurt Riggins in that game, Lewis Ewing. Okay, there's a couple of other, a guy named Blackstone, Tony Davis is very sharp. So there are a few others that have elevated their game while not becoming licensed attorneys. If I were a licensed attorney, I'd have to shut my mouth, which means I made $1.5 million worth of drinks in the 80s for nothing. I'm not shutting my mouth for anybody. It isn't going to happen. 3 arguments. Now, to prove a public servant is a felon, when you understand I can arrest a felon, if you don't deem that to be empowering, I'm available for counseling. Your Americanism needs some therapy, and I'll gladly provide that. On TalkShoe.com, 59615, you'll find a bunch of episodes from me, typically an hour long. or 45 minutes long. I'll take my radio shows that are in 3 15-minute segments and marry them together, so it's 45 minutes with no ads. And then there are other times where I just say, you know, I want to cover a topic and speak on it for half an hour, and I'll record it and I'll stick it on this. TalkShoe 59615. TalkShoe 87488 is American Liberties. My show is called No Confidence. American Liberties 87488. I've been on there for the last several months, once or twice a week, in an hour-long conference calls, taking questions about all of this and promoting. You'll hear, as time goes on, you'll hear this idea evolve to the point where I actually launched the website. 3 modes of enforcement that most affect 99.9% of all Americans. So I'm doing the heavy lifting with these arguments, the masses, but at the same time, they're modes of theft. And so a collateral benefit of pursuing these arguments is reducing the amount of money that bad government gets from us. When bad government gets less money, bad government gets smaller.
Right.
It gets smaller. Okay, it shouldn't be an epiphany, but just to think that it can actually happen, you know, it's not a fishing lure either. This is real. My feet are on the ground with it. Number 1, income tax. I'm going to put tax code. Number 2, state income tax. Let's see, income tax. State income tax. Number 3, motor vehicle code. And I think this is the one I'm supposed to be using. I'm going to attack all 3 of these. The federal tax code is primary. That's our federal government's money. The federal government's money has always been stolen money, and except for just a small group of revenue streams. The entire tax code is theft as it relates to the individual American. I'm a citizen of the United States. When I have so many protections in that tax code, you wouldn't believe it. You wouldn't believe it. I'm a citizen of the United States. And when I am, 2 arguments do the heavy lifting. Number 1, and I'm going to erase this, write this down, take from Caesar.us is just about my materials. Take from Caesar.us. Those same materials are available on WEvGOV.com. My name, David Myrland. First, tax code, proving that everybody enforcing the tax code is a felon. Excuse me. First, Section 1 of the tax code. Tax code is 26 United States Code. It's Title 26. Title 18 is crimes. Title 42 is social health and welfare. Title 49 is transportation. Title 26 is the Internal Revenue Code. 26 U.S.C. Section 1. Section 1 is where we find the graduated income tax. And this is on WEvGOV.com on the federal income taxation page. Section 1 is where we find all the tax brackets for married individual, finally, jointly, separately, head of household, surviving spouse, single individual, trusts, and capital gains. Section 1401, Section 3101, 3111, and 3112. let's see, 3301, I believe it is. These are the chapters, these are in the chapters that they use against us when we're out there selling our labor. We filed the tax returns they say we have to file. We've paid what they call our taxes, and so they aren't after us. But we're out there making a living. 1401, self-employed, Social Security. I'm just going to write self. Social Security, self-employed, 1401, Chapter 2. 3101, employee, Social Security, or FICA, Federal Insurance Contributions Act, Chapter 21. 3111 is the employer. Employer matching FICA, 3111 imposes that tax. And 3301, I believe, is FUTA, Federal Unemployment Tax Act. That comes out of your paycheck also. And the Section 1 tax, which is taken out through the W-4 form. I'm going to put this right here. Through the W-4 form, if you're an employee all year long, self-employed, pay that quarterly. And so, 1 and self-employed, or Chapter 1 and this tax, and this tax. So depending on whether you're self-employed or an employee, you'll pay along that structure. Now, I'm not the citizen in Chapter 2, and I'm not the citizen in Chapter 21. Therefore, my employer doesn't owe any matching FICA in Chapter 21, and I'm not the citizen in Chapter 23, Federal Unemployment Tax Act. That's not me. And it doesn't use the term includes. The term citizen includes, and that makes the government say, oh, it includes everybody, but especially the people that it mentions. Because I'm not mentioned in those definitions, and those definitions don't use the term includes. So they can't broaden them, but they'll write a regulation under those statutes going, the term citizen includes. Well, you can't get permission from that term includes when the statute doesn't have the term includes. And so, I look at the definition of citizen in those chapters. You'll see these on the federal income taxation page of WEvGOV.com. So I'm not going to elaborate much further. Those statutes happen to be 1402B, 3121E, and this goes with it, and Chapter 23, Federal Unemployment Tax Act, 3306J. Definitions of citizen, they expressly exclude citizens of the United States. The only chapter I'm left with is Chapter 1. There. I just proved, and I'm just taking a break here. We're going to kill Chapter 1 in just a minute. But first I want to point out to you that I just proved the Federal Unemployment Tax Act, which was part of the 1935 Social Security Act. It had old age survivors and disability insurance and the unemployment tax. The same definition that's in 1402B in the tax code, the Social Security Act, Section 211, same definition of citizen. Social Security benefits, 42 U.S.C. Section 411B2, same definition of citizen. It expressly excludes me. I'm a citizen of the United States, and it says a person who is not a citizen of the United States, well, put the brakes on, that's not me, but who is a citizen of the Commonwealth of Puerto Rico, Guam, American Samoa, or the Virgin Islands, shall not, for the purpose of this chapter, be considered to be a non-resident alien individual. Well, if he's not a non-resident alien individual, he's a citizen for the purposes of this chapter. And everywhere you go with Social Security, you find that restriction that is simply applies to the possessions. It always has. Tax Code section 7655 says, for taxes imposed on the possessions, see chapters 2 and 21. That's pretty easy. Section 7651, parentheses 4, parentheses capital A. Before 2007, it was parentheses 5, capital A. It was amended. It says any section, any reference in section 28A of the Revised Organic Act of the Virgin Islands to any tax specified by section 3811 of the Internal Revenue Code shall be deemed to refer to chapters 2 and 21. Those are my target chapters, 2 and 21. Doesn't apply to me. And 76514A says, when you're in the Virgin Islands and you see this section 28A of the Revised Organic Act, and it says a tax specified by 3811, it really means 2 and 21. So I went to the 1939 Tax Code, section 3811, collection of taxes in Puerto Rico and the Virgin Islands. A, Puerto Rico. B, Virgin Islands. A photograph of the statute in a copy of the 1939 Tax Code is on WEvGOV.com. So 39 Tax Code, section 3811. There's Social Security. I don't owe it. I've never owed it. In 1965, they added Medicare, which is hospital insurance called 3101B, 1401B imposes that. And so it's always been part of the Social Security Act, which clearly has never applied to Americans. So I've proven first, I'm not subject to these chapters, but remember, the collateral benefit of that is, gosh, are they using the mail to get this money from us? How is that not mail fraud? 18 U.S.C. 1341, frauds and swindles. If anybody devises or conspires to devise a scheme or artifice to defraud and puts any part of that into the U.S. mails, 20 years in prison max. So let's start with mail fraud. Secondly, and this is really the no-brainer, is it a conspiracy against my rights? Don't I have rights to that money? Doesn't that make it theft when they take it? Yeah. And if you don't pay it, we'll steal it. We'll take it from you some way. Well, how's that not extortion? Okay? They're doing it in a pattern of conduct. They didn't just do it once. How is that not racketeering? Felony, city, felony. Okay? All it is felonious. That's all it is. As purely as you can get it. Racketeering and extortion. Social Security. And I haven't even killed the Chapter 1 income tax yet. So I know I'm not the citizen in these statutes. And I go to Chapter 1 because it's the only chapter left. And I go to the statutory definition of citizen. I look and I look. Can't find it. I go to the contents of the tax code. Definitions. Where can I find the definitions? There's no definition of citizen in Chapter 1. But I know from these chapters that they identify the subject of the tax by naming a citizen. Where am I named? They saw this. And they said, what do we do, boss? We got a tax code that doesn't apply to Americans yet. Write me a regulation. Where do we put it? Put it underneath Section 1 of the tax code. 26 CFR 1.1-1. Who is a citizen? Citizens of the United States. Who's that? Any person born and naturalized in the United States and subject to its jurisdiction. Do they owe it wherever they live? Yes, wherever they reside, they owe this tax. It's all in regulation. Section 1 only has the tax brackets that says a married individual. A single individual owes the tax. Individual could be this individual. You got to be more specific. I'm only named in a regulation in violation of the 16th Amendment that says Congress can lay and collect an income tax. It has to be a statute. This shuts down grand jury proceedings. It's done it a dozen times. Criminal Investigations Division of the IRS. We're investigating it. Criminal investigation. And people joined this complaint that I filed 2006 with Congress, and they serve it on the DOJ, the IRS, and it shuts down the Criminal Investigations Division investigation. 6 months ago, we just heard from this guy a couple weeks ago. 6 months ago, his sister and his father had been subpoenaed to appear before the grand jury to learn how he runs his business, how much money he makes, where he spends his money, who his clients are, and he joined this complaint, and I wrote him a letter demanding of the DOJ, you give me the opportunity to appear before the grand jury. And he served this on them. Never heard back from the grand jury. Nobody else has been subpoenaed. This is how it works. You see why I'm not a non-resident alien?
Yeah.
All the protections, I'm a citizen of the United States. I get all my protections out of that status. Chapter 1, that's me. Oh yes, that's me. I'm only named in a regulation in violation of the 16th Amendment. Now, I have 40 cases. You'll see these on the website. Go to WEvGOV.com. It's all there. 40 cases where people went into U.S. District Court or on appeals even. I'm a non-resident alien, or you're the federal government, limited scope of authority. And the courts go, citizen breath, we have this statute, section 1, and this regulation. Americans are subject. And nobody took the time to go, excuse me, that's just a regulation. Where's the citizen identified in the statute? Because we know regulations can't build on a statute. Brown and Williamson versus FDA. Brown and Williamson Tobacco Company, 4th Circuit, East Coast, says in the late 1990s, it appears in the Food and Drug Act, this enforcement of tobacco regulations across the United States is regulation only. There's no statutory authority to enforce their tobacco regulations. In fact, if the FDA had this authority with how bad tobacco is for you, they would have to ban the sale of tobacco tomorrow as a dangerous substance. We don't think they have statutory authority. And they sued in U.S. District Court, beat the FDA. Then it went to the 4th Circuit Appellate Court. The 4th Circuit Appellate Court said, right, it's regulation only. You can't do this. They appealed to the U.S. Supreme Court. The Supreme Court agreed. On WEvGOV.com, you can read both decisions of the 4th Circuit and the Supreme Court together. Those are the book on statutory interpretation and on the tenet of due process that the executive branch can't build on a statute through regulation. So, I make the same accusation about the structure of the tax code. You're enforcing a regulation when you speak to me about income taxes. That's this box. Over here, you're stealing, and it's felonious. I have the right to arrest you. Checkmate. Why do you need another argument? I would never dissuade somebody from making an argument they believe in. Go for it. When you lose, you have to be prepared to make another argument. That's all. This is the only one I've chosen to learn. It's the only one I would use because it's statutory. It's in the box. Okay? So that's the first challenge to the tax code. And it's all right there on WEvGOV.com, the federal income taxation page. Number 2, state income tax. Oh, I'm sorry, I'm not here yet. I'm going to back up a second. There's a second challenge in the tax code, and I'm getting pretty crowded up here. So that's the first challenge. Set that aside.
There we go.
Section 83A. It's a paragraph. And it's bad news. The reason I'm so hot to go for Section 83A is because I don't have a choice. The courts, tax court, 9th Circuit, 6th Circuit, 5th Circuit, 2nd Circuit, other circuits, and the IRS General Counsel say that Section 83 applies to all compensation. It explains how to tax it. It governs the taxation of compensation for services. It provides for the determination of what is to be included in gross income. And the IRS has operated for decades by saying, your paycheck is gross income. Section 83 has to have operated. None of us have a choice. If it screws me, I'm screwed. It's the law. If it protects me, I want those protections. Is that too much to ask? Not if you listen to the IRS and the DOJ. The tax has to be imposed by an operation of the law. He has a legal duty. He's willfully failing to file a tax return. Okay, and it's about the law. First, you're willful. If you have a legal duty, you know and believe you have the duty, and you fail to perform the duty. Everybody attacks the middle one. I don't believe I have a duty. Look at this long list of documents I've served on the IRS over the years, and they never responded to prove to me I have a duty, and so I'm not willful. I don't believe I have a duty. Lloyd Long, John Cheek, Vernice Kuglin, maybe some others. I attack the first prong. I don't have a legal duty to believe in the first place. I'm only named in regulation. And even if I were subject, how did Section 83A operate? In your conclusion, I owe a tax. Why is Section 83 such a problem? It doesn't say your whole paycheck's gross income, and it applies to independent contractors and employees alike. It says if, in connection with the performance of services, property is transferred, the excess of the value of that property over the amount paid shall be included in gross income. And it doesn't say the amount paid should be included in gross income. Regulation defines the term amount paid as the value of any money or property that you paid for your paycheck, for your earnings. Any money or property. Labor is property. And this regulation says any. And in the 90s, I got nowhere. They said, you didn't buy your labor first before you sold it, and so everything you reap when you sell your labor is a profit. And the argument was always, where's your authority to exclude some property like labor from the value of any money or property? And they'd never identify their lawful authority to exclude from any money or property. Then 5 trips to the Supreme Court by October of '98, I got nowhere. Then in 2003, I found 4 U.S. Supreme Court cases that the government won, where the government argues you have to identify a law that allows you to make an exception to the term any property. So the government won 4 times in the Supreme Court arguing the way I argue. So I beefed up the brief, rebriefed it with a big excerpt from those cases, and went right back at it again. So they don't have that authority. Now there's one case where they actually went on record in tax court saying, you didn't buy your labor before you sold it. And these were clients I met in the early 90s. 5 trips all the way to the Supreme Court. And in one case, Talmadge versus Commissioner, they articulated the reason they don't let you get a deduction for the cost, for your labor as a cost, because you didn't buy your labor before you sold it. Appealed to the 4th Circuit, and the 4th Circuit said, based on what tax court says, give us a break. You owe taxes on your labor. And now that I've rebriefed it, they don't cite Talmadge in their defense, even though it was an appellate victory. Because those 4 U.S. Supreme Court cases the government won prove that it's a faulty interpretation. So they don't even cite an appellate victory, the only one that went on record against Section 83 with a reasoning as to why the argument is mistaken. So I keep throwing it in their face. So these 2 arguments, this is number 2, and this is number 1. I'm only mentioning a regulation. And if I were subject, how does Section 83 operate? In your conclusion, I owe a tax on the value of my labor. They're out. Now, back to the movement for a second. Apologize. Income tax is collected through voluntary compliance. How did Section 83 operate? In your conclusion, it's a tax that they take from me. They can't answer because they didn't read the tax code. I found Section 83 by doing what? It was amazing. I read the tax code. That's what separates me from the whole anti-tax. Give me a break. They have to admit they've never read the tax code, or they would have come across a statute called property transferred in connection with the performance of services. Sounds like a paycheck to me. When I first found it, first thing I thought, and it's true today, if this applies to me, it's not being enforced. It's true today. 23 years later. And I've got 2007-19 revenue ruling. IRS Chief Counsel. Section 83 provides for the determination of what is to be included in gross income when property is transferred to an employee or independent contractor in connection with the performance of services. Everybody agrees. 2011, Second Circuit, Goodmanson versus United States. At the heart of this case is Internal Revenue Code Section 83, which governs the taxation of property transferred in connection with performance of services. Everybody agrees, and no one has a choice. This is where you start. Because if you don't start there and start in gross income, you just lost. I've been deprived of the provisions of Section 83. And I'm only named in a regulation. First things first. They shut down the grand jury proceedings. This isn't magic. This is statutory interpretation. That's all it is. But it's at the root of everything. And to get down to the root of everything, you go through all those other arguments that other people are making. You see them run a million different directions. And some of them are putting a couple pieces together, like if you don't pay FICA on your tips, they can't take you to tax court over it because a notice of deficiency doesn't apply to Chapter 21 taxes. And so you get away without having to pay FICA on your tips. Little things here and there, but they don't get down to the basics. When I teach you these basics, understand it's 1/100th of what I learned about the tax code. This isn't the first argument I learned. This is after years of research and learning all kinds of arguments that I've briefed. I narrowed the list of 17 differences between the law and the IRS down to like 4 that really do the heavy lifting. And those are the ones I key upon because they free the slaves. They prove the racketeering and extortion. Therefore, they lend the authority to make a citizen's arrest. They level the playing field with your servant. And at the same time, they shrink government. I can't get over that one. Now, state income tax. You'll see on WEvGOV.com a state income taxation page where state by state, as I find time to do the research, I'll go to a state tax code and look up the place in the state tax code that says your state liability or your state requirement to file is based on your federal requirements, your federal debt of income tax. There, they just gave me a nexus to the fact there's no liability in the federal tax code for me. If there's no liability fed, there's no liability state. California made it really easy. California here, and California, by the way, we're going to talk about in just a minute. California Code Section 17081 says something to the effect that Subchapter O of Chapter 1 of the Internal Revenue Code is hereby adopted into state law. I don't know which subchapter they say, but the subchapter that they name here as incorporated into state law happens to be 26 U.S.C., which is the tax code, sections 71 through 90. Is Section 83 in there somewhere? I think so. Section 83 is state law. They said we adopt that subchapter of the Internal Revenue Code. And I look up that subchapter, it's 71 through 90. Bingo. Okay? So Section 83 is state law. And we're on the attack right now against the California Franchise Tax Board. Right? Because if the IRS can't answer it, the state taxing authority can't answer it. It's one statute. What are you going to do next? Then we're going to the sheriff. That's what we're going to do next. It's going to be on his desk. So, that's how easy it was in California. They got a couple other sections. The argument is actually, I've been deprived of Section 83, 212, 1001, 11, and 12. 212 is a catch-all statute that says in the, let's see, it says, in the instance of an individual, there shall be allowed as a deduction all ordinary and necessary expenses paid or incurred in the production or collection of income. So it's a general cost is deductible statute. Under Section 83, regulation 1.83-4B2 says to figure your cost, you can also apply Section 1012. 1012 is called basis of property or cost of property. Its first regulation says your cost is cash or other property. I don't see them excluding property that I didn't buy before I sold it, like my labor. And so I include labor in that. 1011 says the basis, and 1012 is also known as the adjusted basis. That's all it does, it renames it. And 1001 says upon the sale or exchange of property, there shall be, it shall be restored to the taxpayer. The adjusted basis in 1011, what's left constitutes the realized gain. So it's a little equation you can follow. But it's the same thing as 1.83-3G that says the amount paid is the value of any money or property paid. So there's two ways under Section 83 to determine the amount paid. They have to be the same result, don't they? There's not two different equations, okay? It's all the same. And the history of 1001, 11, and 12 is 1939 Tax Code, Section 111, 12, and 13. So it's an old standard. It's always been there. All property is a cost. Put that in the box. Next box, it's all felonious. And with that, that's where the gold is. It levels the playing field. Once you prove felony misconduct, you have rights that equal the rights of the criminals. So, I go to the state tax code. In some states, it's real difficult to find the provision that equates the state liability with what you ultimately owe on the federal side. So all these states, I think there's 45 states now that impose an income tax. I think New Hampshire is only on dividends. Go to the state income tax page of WEvGOV. That's where you'll find these details. And some state tax codes are very difficult to analyze. Oklahoma was a real drag to try to find the ground level nexus with the federal tax code. That's the way I attack state income taxes. If they say outright, your state income tax is a portion of your Fed, and I can prove on the federal level that I'm only named in a regulation, Section 1 has the capital gains tax. And if I'm only named in a regulation, I just prove I don't owe capital gains on the federal level, and therefore I don't owe capital gains on the state level or tax on my compensation for services on the state level. So these work together, and you don't have to know every state. We're in Washington. We don't even have an income tax to deal with. We came close. And me and another guy filed a criminal complaint against the governor and the director of revenue for conspiracy against rights. They made a criminal attempt under state law and a conspiracy under federal law to commit grand larceny against 6.6 million Washingtonians, 6.2 million Washingtonians, by passing an an income tax that they knew by law wouldn't even apply to people, but they were going to do it anyway. So, which leads us to Motor Vehicle Code. Law across the United States. On the Motor Vehicle Code page of WEvGOV.com, you'll find a paragraph near the top of the page that says, this complaint was filed March 9th of 06. This complaint is a link. Click on it, and a page pops up with a photograph of each page of the criminal complaint that Kurt Riggin and I filed March 9th of 06 with the Department of Justice and the Homeland Security Committee in Congress when former King County Sheriff David Reichert was a rookie member on that committee. He was named as a defendant in the caption. And we filed a criminal complaint with his boss proving he was a felon, because law from coast to coast says highways are open as a matter of right to public vehicular travel. Public vehicular travel is the name of your right to travel in the eyes and mind of your legislatures. And so we wrote the criminal complaint in the brief, signed it, and filed it. I've never received so much as a punctuation mark in response. And people go into court with this and demand that the officer be at the hearing held on the traffic ticket, and they typically tell the officer not to appear so they could dismiss the ticket and not get into the topic of public vehicular travel. Now, Codebreaker, the Section 83 equation, is a manual I wrote in 1994, and in March of this year, 2014, I added 30 pages to it and published it, as you can see. It's a copyrighted work devoted entirely and only to the language of Section 83 and how those, the terms of the statute should be enforced, what they mean, and this is the foundation of the briefing that I use. It's all right in here, including a list of federal criminal statutes at the end and a list circuit by circuit, quote by quote, of all the cases that say reasonable suspicion to believe a felony has been committed gives you the authority to arrest the felon. It's all in Codebreaker, the Section 83 equation. There's no one else that teaches this statute, which means everybody else is 23 years behind me. I wrote my treatise on the tax code in 1994. I was teaching this in late 1992, and I'm still the only one teaching it in the known universes. There's no excuse. This reached the web just about a week ago. Take from Caesar, Volume 1 and 2. Volume 1 is the criminal complaint that I filed with nearly 80 members of Congress January 1st of 06. This is the entire complaint with exhibits, table of authorities, everything that I filed with Congress is in this volume to show you the allegations of criminal misconduct that I made based on my treatise and a few individual instances of abuse that were in fact criminal are alleged in this. But the first 7 of the 22 counts, the first 7 counts bring my treatise to bear on the IRS, saying this mode of enforcement, this mode, this mode, this mode, 7 different counts. The rest of the counts are, over here in this trial against that guy, they behaved a certain way and it was a violation of his rights. So that's an isolated instance. But the first 7 are the 7 crimes I feel that enforcement constitutes when in fact my findings are deemed correct. Then there's a table of authorities, 7 or 8 pages of all the cases, an abstract of primary claims, 12 pages that say, these are my claims, this is what I'm trying to explain. So you can go slowly through the abstract of primary claims and learn exactly what I'm trying to say in a nutshell without a great big old briefing you have to sort out, because when you're reading the brief, you know, your eyes roll back in your head from all the numbers and the names of cases and trying to parse that out from the language of the argument itself. And then we get to the table of authorities, a list of all the statutes, footnote directory, and all the cases cited, alphabetical order, in the 58-page memorandum. This is what people join when they say, I've looked at your findings and I believe that I'm a witness to crime, or I'm in fact a victim of crime through the misenforcement of the Internal Revenue Code. You don't have to write another memorandum, another complaint. You simply contact my office or WEvGOV.com, the website about which this meeting is being held. Welcome.
Thank you.
The party then signs an affidavit that explains, I feel these violations are occurring, and my office will mail those to the right people in Congress and mail you back a certificate of service to prove that my complaint is now your complaint, because you're a co-complainant. In Volume 2, and that was January of 06 that was filed. In Volume 2, The 2014 supplemental briefing. August 27th, I filed a supplemental briefing behind that complaint with 3 committees. So Congress knows I have an up-to-date brief since 2006. A couple things have happened. We've been to court on this, and the government runs from these provisions. And so I supplemented the brief. Let's look at the photograph. See what that is? That's the one of the Federal Reserve banks in negative.
That's right.
The book is called Take From Caesar, meaning it's a ghost. Take from Caesar that which is not Caesar's. It's a negative on purpose. You can take away the title and look at that picture and know this is about the demise of the puppet master that's in charge of our government. Our government serves this puppet master and it's over. That's why it's in negative. So volume 2, my supplemental briefing filed August 27th of this year to acquaint Congress with the fact that we have the Second Circuit, 2011, Goodmanson versus United States, Section 83 governs the taxation of all compensation. So you can't run from it, and it protects me. As well as Internal Revenue Ruling 2007-19 that says 83 is universally applicable. And if, in fact, our late arrival is unfamiliar with my work...
No, I'm very familiar with it.
Ah, okay, so you know about Section 83?
I know about all of it.
Oh, uh-oh. Do you have your government ID handy? Anyway, Revenue Ruling 2007-19 is in here as an exhibit to that supplemental briefing, as well as the IRS's, I think it's the 2007 edition of their frivolous argument list is in here as an exhibit. And then, and this is exciting for me, I have no life. This is exciting. The United States plaintiff appellee, Joe Lunchbucket, defendant appellant. In a tax evasion case, there's a man, this hasn't even been filed yet, this is a Joe Lunchbucket brief. I wrote this for a guy that just pled guilty to 1 count of tax evasion to keep the number of months in prison down. He was charged with 2 counts, and he filed some exotic Patriot Movement crap that if he went to trial on it, they'd supersede the indictment with more counts, and he'd go to jail for 10 years. So he pled guilty to 1 count, got 40 months, and contracted with me to write his appeal. And here's a 48-page memorandum beginning on page 126 of volume 2. And it briefs the first argument. I'm only named in a regulation, so the indictment is invalid, and I'm not guilty. Secondly, this is a tax evasion count over Chapter 1 taxes. I was self-employed. You deprived me of Section 83 to say I even owed a tax to evade. The conviction is not valid. And issue C. When in court with these issues, the government runs this direction, it runs this direction, it runs this direction. And the briefs against these arguments have nothing to do with one another. They're entirely different from one another. You can't expect, when the courts can't even settle on a particular answer to an argument, you can't expect the individual of ordinary intelligence to understand the tax code, and therefore it violates the void for vagueness doctrine, due process, to criminally prosecute somebody under the tax code. This is going into an appellate court within a week and a half. His deadline is like the 3rd of next month, so it's going to court right away. And in here also after that, you see there's a table of authorities. It better be in here. I got the bonus plan with this one. I thought the table of authorities would be in here. Hang on. Okay, it's not in there. Anyway, we're putting out a 2nd edition. There's a couple things I wanted to change about it. Anyway, the void for vagueness doctrine is the 3rd issue argued in that memorandum. And the only thing that's been changed is the docket number and the name of the litigant. So volumes 1 and 2 of Take from Caesar, brand new. I got ISBN numbers on it. They've been published, and they're on WEvGOV.com. Pick them up right away. Volumes 1 and 2. It's the best desk reference ever written for the tax code. Period. Now, the tenets, the original footing for the panel that will assess evidence and provide accusers with written statements saying, we, the panel, we believe felonies have been committed, and give that statement to the accuser so they can go to the boss of the accuser and say, do I have to arrest him or are you going to arrest him? After proving that all of tax code enforcement is felonious, everybody you see every day serving breath can arrest you. State income tax. California Franchise Tax Board is first. California group is hot to go. I've got a dozen people down there building up steam now. Hi, California. And the Motor Vehicle Code. Public vehicular travel is a right. You'll see on the website, I don't have a copy of it with me today, but it looks just like this, except it's got a picture from the Rodney King beating video here. Public vehicular travel, America's Forgotten Right. That manual is for sale on WEvGOV.com as well as on takefromcaesar.us. The panel is going to begin by serving the governor of the state with a briefing of how Section 83 is state law through that California statute, that the Franchise Tax Board is engaged in felonious extortion and racketeering on a statewide basis, and we can arrest them. And you've been served with this criminal complaint by the panel at WEvGOV California chapter. Then a letter is going to go on top of that to the sheriff of any county in California saying, you've received a criminal complaint that's been served on the governor, note that it has a certificate of service, all that good stuff, and we expect you to, full colon, 1 or 2 or 3. Number 1, get them to cease and desist right away. Arrest, first, disprove the argument by telling us how Section 83 has operated when they take money from us as a sole proprietor, independent contractor, or employee. Number 2, get them to stop, arrest them, and seek charges. Or number 3, tell us where we can deliver them, or anybody can deliver them if they make a citizen's arrest of their person. It's 1, 2, or 3.
Right.
Which one's it going to be?
Yeah.
It's a dead end. The federal government can't even answer. And what this does, you put all that in a box, and then you take your box full of rights and you put it right beside and you go, we're equal. The playing field has been leveled. I have the right to arrest a felon. And by the way, the citizen's arrest case law is not only in the back of the Section 83 manual, it's also in the back of the public vehicular travel manual, and it's free posted on the citizen's arrest page of WEvGOV.com. All the cases, circuit by circuit, federally, district court by district court, all of the cases are cited and quoted on that page. On the federal income tax page, each of the 40 cases where the government says, you're not a non-resident alien, we're the federal government, we have the authority, here's Section 1, and here's the regulation that says you're liable. All 40 cases are quoted on that page, free, to show you. 40 times the government runs to that regulation every time to say, U.S. citizens owe this tax. And not one of them said, excuse me, but that's just a regulation, Your Honor. I make the argument, excuse me, that's just a regulation in violation of the 16th Amendment that says only Congress can collect this tax. Do you have a statute that names me as subject? And in Alaska they said, oh, he's claiming to be a non-resident alien, Your Honor. No, I'm not. I'm claiming to be a citizen of the United States like you said I am. And senior judge, Anchorage, Alaska, U.S. District Court, senior judge Ralph Beastline don't laugh, said, we agree. That he's claiming to be a non-resident alien, rather than get into Section 1 and the regulation to describe how the argument about the regulation is mistaken. Oh, he's claiming to be a non-resident alien. The judge says, I agree. You horses, South End, spare me.
What do you expect?
No, I expect exactly this, but to underscore it here for the purposes of this meeting, look at how far they had to run, 15 furlongs. The horses Patu had to run 15 furlongs to get away from this argument. Look how far they're willing to go when they'll be the first ones to tell you you're a citizen of the United States. Hey, great, sure. Do you have a statute? He's claiming to be a non-resident alien, Your Honor. And that was the basis for sending an old man to prison for tax evasion. So I've got the goods on him, and this is reflected upon in the void for vagueness argument in Volume 2 of Take from Caesar. The whole brief is right there, saying how can you expect an individual of ordinary intelligence to know when we have a U.S. District Judge, Chief Judge Robert Lasnik in Seattle says one thing in a paragraph, and 4 or 5 months later in Alaska they say non-resident alien in a totally different response to identical briefs of that argument. And on Section 83, Talmadge versus Commissioner, 1995, Tax Court Docket number 339-95, goes to the Fourth Circuit, and everybody agreed. Since you didn't buy your labor first before you sold it, everything you make is a profit. But when you face them down with Section 83 now, because of those 4 Supreme Court cases, the government one that says any property, you have to have the law that excludes something from the term any property. And they don't have a law that excludes labor from the value of any money or property paid that's not gross income. They don't even cite Talmadge when it's the one correct answer. And it was a Fourth Circuit victory for them, and they don't even cite it because it proves they don't have a law that allows them to exclude labor from the amount paid in Section 83. And 83 provides only the excess over the amount paid as gross income. So the panel is going to start with those 3 and exert the pressure that comes from the right, the common law right, governed by state law, regulated by state law, the right to arrest a felon with any necessary force. All of this is already free on WEvGOV. If you want to lay your hands on the briefs that are behind all of this, buy the publications. The panel is looking for people in other states that want to start a chapter. They have to be people that understand if they mention at any time in association with WEvGOV any of the arguments waged by the anti-tax movement, the patriot movement, sovereign citizens, whatever you want to call them. They're all in one group and they're way over there at the opposite end of the learning curve. If you mention anything they do, you can only kill the credibility of the panel. You're out. You're out. We'll put it right on the web. These people no longer have anything to do with us. They've obviously lost their minds. But on the lighter side, there's a group in California that says, that's for us. We just put the patriot movement in our rearview mirror, and we aren't going to look back. We just got the authority. We leveled the playing field against bad government 99% of the time. Through tax code, state income tax, and motor vehicle code analysis. We just got 99% of the authority we were looking for. The other 1% is how we're treated in individual instances. So the California panel is first going to file a complaint with the governor. And they're not going to build on my congressional complaint. We're going to start a brand new complaint, ab initio, with the governor. This is felonious. And beam it right at California state income taxation. And start there so people in California can go to the panel and say, I believe the argument, I've watched the videos, I've been to the website, I got the publication, let's go. They deprived me of Section 83, of 17081, California Code section. They deprived me of this. I believe it, and I think it's felonious, and I can't wait to put my name under oath to a document that says, I hereby accuse John Chang, chairman of the California Franchise Tax Board, and we'll file it with the government. I just can't wait. And that person can go to the panel and file what's called an affidavit of joinder and make the panel's complaint their complaint. They now can take that to their favorite agent of the Franchise Tax Board and serve it on them and say, is it convenient to arrest you at work or at home?
Yeah, which way you want to do it, or in church.
How's it going to be? And put that in writing, please, because it's over. And move on. Motor Vehicle Code. Officer, you really need to keep that pen in your pants, because if you take it out, the only thing we're going to talk about in traffic court with you on the stand is public vehicular travel. You saw the sticker in my rear view mirror, and so you know I'm part of this effort of WEvGOV.com. What are you doing pulling me over? You know all I'm going to talk about to your judge is whether or not I can arrest them. What were you thinking? You're free to go. Well, I don't need you to tell me that. So I encourage, and none of this is legal advice, that panel members or enthusiasts that are ready to wield this argument and know others, get a window sticker and notify the local cops. This is what you're in for when your pen leaves your pants. Don't do it. There, that's one less person that's going to give money to a government that steals every penny it gets. Now, Motor Vehicle Code. If you went back, as Kurt Riggin did in Washington State here, to the first Motor Vehicle Code, you're going to find the Motor Vehicle Code applied to commercial vehicles delivering commodities or persons or goods. They weren't engines in these vehicles. They were motors. Motors are electric. To run a motor that's big enough to push a truck up the street and back, you got to have a battery half the size of the truck.
Yeah.
Do you know how much that weighs? The tires were the first tires they invented. They were hard, and those trucks would screw up every street they drove up. We got to regulate this. The streets are going to pot here. And so we're going to regulate motor vehicles. And when you, the driver of this motor vehicle, you see a weight sign on this other road that you could turn off on that says nothing over 10,000 gross, that's you. Your truck is too big. You don't go down this road. And you put a sticker on the side of your truck saying how much gross is your limit. That's the regulatory scheme that was originally put in place for electric motor vehicles. And in time, if you did this research in your state, like Kurt Riggin did in our state, you find over time, nowhere has the legislature ever expressed an intent to broaden that definition to include other subjects. All they did was hide it through language. But now you still have in the law, especially here in Washington State Attorney General's reports, municipal code sections, and state statutes that highways are open as a matter of right to public vehicular travel. Go to the Motor Vehicle Code on WEvGOV.com. And so they're going to put a complaint into the governor in California complaining about this one also. And then it's a matter of, you either have to leave me alone or you have to shut down traffic court. Because me and my friends, we know where all of you live. And you can't deny a word of this, or you'd have denied it by now. And so we're not here to play games anymore. The game is over. We're taking our ball and we're going home. And you simply call a halt to it with the promise that citizens' arrests are likely. If it isn't me, it's going to be somebody else. We got a website. We got a YouTube channel. We're going for it. You're the brunt of jokes. Do you want your picture on the web, or do you want to keep that pen in your pants? We all have choices to make, officer. I'm not trying to threaten you. I'm just saying, I got rights everywhere that you don't know about. That's all. So, WEvGOV.com is now on the web, WEvGOV.com. TakeFromCaesar.us, and the two talk shoe channels. 59615 is my channel for my show called No Confidence. My show, big deal. It's nothing like you'd hear on professional talk radio. But 87488 is American Liberties, and Chris Chapman and I are the ones that started WEvGOV.com. And this will be posted in a couple days as the introductory video for WEvGOV.com. And we support our effort through the sale of the materials. You'll also see on WEvGOV.com a flash drive that has 3 hours, 45 minutes of video instruction shot in 2003, where at a whiteboard this size, I explain my whole treatise on the tax code in 7 different segments. You really got to get those videos. If you're like me and like a lot of other people, to sit and read a legal brief and sit, your eyes will roll back in your head and you'll get a headache. If you want to watch videos instead that explain the tax code, get the flash drive. It's a great start to your education, and then you'll see other publications available also on WEvGOV.com. My name is David Myrland. None of this was legal advice, and stay tuned to WEvGOV.com for developments. California is about to go up in smoke. Cool. Thanks.